Hello everyone. Today we are going to discuss about bail. Bail deals with section 2B of BNSS, that is Bharatiya Nyaya Suraksha Sanhita, which says that a bail means the release of a person from a custody of law who is accused of the commission of the offence or who is suspected of a commission of offence upon imposing certain conditions on him. Now basically there are 5 types of bail. First, bail in bailable offences. Second, bail in non-bailable offences. Third, anticipatory bail. Fourth, default bail. And fifth, bail upon conviction. Now we will discuss each type of bail one by one. First, bail in bailable offence. Section 478 of BNSS deal with bail in bailable offence. Basically, there are 6 types of offences. But insofar as this topic bail is concerned, we will discuss only about 2 types of offences. First, bailable offence, and second, non-bailable offence. If any person is accused of or suspected of commission of a bailable offence, the bail is a right of that person. That means that there is no discretionary power conferred upon the court to deny the bail, and here the bail is a right of that person. Second is bail in non-bailable offences. Section 483 and Section 480 of BNSS, that is Bharatiya Nyaya Suraksha Sanhita, deals with bail in non-bailable offences. Bail in non-bailable offences means the bail granted to any person who is accused of commission of non-bailable offence. Here, the bail is not a right of that person, and the court holds the power to grant bail or not, whether to grant bail to that accused or not. Which means basically, here the bail is not mandatory but subject to the powers of court. And if court thinks fit that taking into consideration the circumstance and the facts of the case, that the bail is to be granted to the accused, and the court can grant bail to the accused in the case of non-bailable offences. Now the third type of bail is anticipatory bail. Section 482 of Bharatiya Nyaya Suraksha Sanhita deals with anticipatory bail. Anticipatory bail basically means that the bail in anticipation of arrest, which means if any person who apprehends his arrest or who has a reason to believe that he may be arrested, he can apply in the sessions court or a high court for anticipatory bail. And if the court thinks fit that anticipatory bail shall be granted to the person, then the court can grant him the anticipatory bail, and in the event of arrest, he may be enlarged on bail. The key point to be noted here is that the lodgement of the FIR is not an essential condition for the application and disposal of anticipatory bail, because the words employed is apprehension of arrest, or if any person has a reason to believe that he may be arrested on the grounds, then he can apply for anticipatory bail. And if court thinks fit that he should be granted bail, considering fact and circumstance of the case, the bail is granted to the person. Also, there is one more type of bail which is associated with anticipatory bail, that is interim bail. Interim bail basically means that the bail is granted to a person before the final disposal of anticipatory bail. Until the final disposal of anticipatory bail, the bail is granted to the accused. That is called interim bail. The other type of bail is a default bail. Default bail deals with section 187(3) of Bharatiya Nyaya Suraksha Sanhita, that is BNSS, which means that if police officials fail to file the charge sheet in the stipulated period of time, that is, it may be the period of 60 days or the period of 90 days, depending upon case to case. If the police fail to file the charge sheet In that case, the accused is entitled for default bail, and the accused is rightfully entitled for default bail, and the default bail is always granted to the accused on this ground. Basically, default bail means if the police is not investigating the case, or if the police is not filing a charge sheet within prescribed time limit, then the accused gets the benefit of this failure of the police and he can apply for default bail. Now, the last type of bail is bail after conviction. Section 430 of BNSS deals with the bail after conviction. The bail after conviction basically means if any accused person is convicted by the lower court, then he can apply in the upper forum for the suspension of sentence and for the enlargement of bail. So pending disposal of the appeal from the High Court or the higher forum, the accused gets bail, and that is called as bail after conviction. It deals with section 430 of Bharatiya Nyaya Suraksha Sanhita. So today we discussed about bail and the types of bail. In the next video, we will discuss about the purpose of bail, the objectives of bail, and some case laws which are very important, which are very paramount in considering bail. Thank you.